was late last year, wasn't it? Because obviously this has been on the radar for a wee while. And it was going to be a seminar, and even though we had been talking about it for a couple of months, I didn't know anything about it. So yeah, this has forced me to learn a bit about it myself. I'll just stop sharing the results. So we've got another poll that we'll do later on. But yes, we will 2:05, so we're going to kick off. So thank you, welcome everyone who's joined our webinar today. So this is an IT team webinar with generally IT team customers or contacts, and we're doing this in partnership with neave, who are the subject matter expert of this this webinar, which is NZ's privacy law changes. So what we're trying to do today is give you a bit of a high-level overview of the change, maybe how it does impact your organisation, the type of data you may carry, or how it relates to the type of data you may carry, and some protection measures. And that's, I guess, where the IT team comes in. There's a bit of new content we're going to share that we've been working on that does relate to this. And it could give a few ideas for our customers and the contacts in here on how to approach what you can do about, I guess, the changes to the law and protecting the data that could result in a fine or just losing data. Yeah, obviously most people in here will have seen myself or spoken to myself once upon a time. My name is Colin Daly. I'm the General Manager of the IT team, and I'm joined by Graham. Graham, would you like to give a little bit of an intro?
Thanks, Colin. Yes, so I'm Graham Crombie. I'm one of the corporate partners at neave. I specialise in the technology area, including privacy and data protection. I do a lot that involves technology contracts and generally, and privacy matters that relate to them, including procurement issues, and IP comes up a lot in technology contracts as well. A little bit about neave for those of you who don't know neave. Have you got the next slide there, Colin? Thank you. neave is slightly more than 150 years old. We were first established in 1868. We have offices now in Christchurch, Auckland, Wellington and Queenstown. We're a full service law firm, which means we provide legal services in pretty much every area of the law. Key ones include corporate, commercial property, dispute resolution and employment. We have specialist expertise as well, as I noted before. And in the technology space, some of my previous work has involved some quite large projects. For instance, I helped EDS when Telecom, as it was then, and also Fonterra had outsourced their entire IT to EDS. I help both customers and tech vendors, from startups to SMEs through to large corporates. And the key thing about neave is our aim is to make complex legal problems simple by providing relevant and practical advice. And my aim today is to distill down the new Privacy Act into some of the key elements that people need to be aware of.
So they don't have to read the act themselves. Sorry, excuse me, Graham. So yeah, look, just a couple of extra things I should add before we go into what we're going to cover today. If you have any questions, please feel free to fire them through. We'll either get to them during the webinar or we'll get to them at the end. And yeah, we should hopefully be finishing up our core content around about 2:50, although as some of you who attend my webinars, I'm always running late. But yeah, we'll have a few questions, and generally, if we're running a bit behind, we'll continue some questions after the 3 o'clock mark for those that wish to say and ask. And also there is a survey at the end we'd really appreciate. It's if you would be able to fill it out. We love to get the feedback, helps us do better and develop our ability to do these, and it will also, there's also an opportunity for you to give some suggestions in there, which are great. So yeah, please fill that out. All right, so what we're going to cover today, so a little bit about the timeframes that have, I guess, contributed to the Privacy Act change. Then we're going to go into the key changes to the information privacy principles. Had to write that one down. Some information on the notifiable privacy breaches, some other key changes including the fines and the new powers for the Privacy Commissioner, which is really interesting. Then we're going to talk, or I'm going to talk a little bit about the protection options, some of the priorities around privacy and security now and recently what they have been. We've got something called the security scale to go through, which could give you some ideas on where you should head with your security protection. And then we delve a little bit into the M365 for a moment. We're going to cap it off with what you need to do, an area to focus on generally with regards to how you should approach the upcoming law change. And then we're going to have some time for questions. Brilliant. So take it away, Graham. Timeframes.
So just a quick recap, really. The privacy legislation has had a long gestation period. Originally, about 10 years ago, the Law Commission made a bunch of recommendations. After quite some time, a bill was finally introduced into Parliament. That was just over 2 years ago now. It slowly made its way through Parliament and gained the royal assent, the final element of making a new law, on the 30th of June this year. The new Act, Privacy Act 2020, comes into force on 1 December this year. So we've got a few months to get our house in order. So we're going to run through the three key areas that relate to what's different between Privacy Act 1993, the current law, and Privacy Act 2020. We'll start by looking at the information privacy principles. The key part of this is understanding what actually the Act applies to. So the Act applies to all types of entities, and the Act calls them agencies. And this is not to be confused with government agencies. It applies to both the public sector and also the private sector. The scope relates to personal information, and that is distinct from corporate data, to which the Act does not apply. And that's quite an important distinction. How we work out what personal information is, we turn to the definition. The definition is very straightforward, having only a few words to it. Information about an identifiable individual. However, each of those words is very key to understanding this term. Information, that means pretty much anything from like a name through to an IP address. The word about here is really important because there needs to be some sort of link between that information and the next part of the definition, an identifiable individual. For instance, if the information recorded somewhere is simply 5'11", it's not of itself personal information. However, if there was some additional attributes, for instance, it said Graham's height is 5'11", then it is information about an identifiable individual. And the term individual is also key in this as well. It means a natural person other than someone who's died. So the legislation is only applying to humans and not robots, animals, or organizations itself. So most people should be familiar with the existing IPPs. So if we now have a look at what's changed with them. So currently there are 12 IPPs, and they cover collection, use, disclosure, and storage. 5 of the IPPs change under the new 2020 legislation. They are only small changes, but some are quite subtle and important to bear in mind. But the good news is the bulk of the IPPs are staying the same. So current practices will go a long way to ensure you comply with the new 2020 legislation. There's also one new IPP, which we'll get onto shortly. So what are the changes to the IPPs? So IPP 1, which relates to needing a lawful purpose to collect information, has a slight change to restrict the ability to collect identifying information. What it's saying is that if you have no real need to identify the individual to whom the information is being collected, then that identifying information should not be collected. IPP 2, which relates to who you collect the information from, this just has a very minor change, largely for consistency with some of the other IPPs. It will be possible to collect information from people other than the individual concerned if there's a serious threat to life or health. IPP 4 is another interesting change. So this relates to the collection of information, the manner in which information is collected. And what the change says is that we need to take greater care when collecting it from children and young persons. So think more carefully about why that information is going to be collected and how you'd collect it from them. In relation to use and disclosure, IPP 8 is the requirement to check the accuracy of information before it's used. This has a slight adjustment to also require accuracy to be checked before disclosing that information. We'll skip over the next one. IPP 13 relates to unique identifiers, and the change here is a requirement to minimize the risk of misuse with a unique identifier. This already happens quite a lot. You will see receipts with the credit card details truncated so that the full detail isn't set out, bank statements that only have part of the account number. So this is really just enshrining some practice that generally happens already. The key action out of this is to check your privacy practices and your policies, so internal policies and external privacy statements, and make sure that they align with these few tweaks to the IPPs. Turning now to the new IPP number 12. So principle 11 relates to disclosure of information, and this new principle 12 adds a little bit more to that requirement. What IPP 12 is saying is if we are going to disclose information outside of New Zealand, in certain circumstances, we're going to have to meet particular criteria. Now, the key thing to remember here is that using a service provider who may be based outside New Zealand is not necessarily a disclosure. If that service provider is merely holding the data or processing it on your behalf, then that is not disclosure to the service provider. However, if the service provider or another entity is going to use that information provided to them for their own purposes, then that will be a disclosure. And that will bring this new IPP 12 into play. And what it says is that that type of disclosure to an entity outside New Zealand is only permitted if one of 5 criteria are met. The first possibility is that the individual has authorised the disclosure. So in other words, you get their consent to disclose it outside New Zealand. Secondly, if the recipient is subject to the new Privacy Act, and this could arise because they do business in New Zealand as well, or they are subject to privacy laws that provide comparable safeguards. And an example of that would be Europe's GDPR. The third option is they're part of a prescribed binding scheme. There are no such schemes at this time, but regulations may put one in place at some point in time. The fourth option is they're subject to privacy laws of a prescribed country. That probably overlaps a bit with the second one. However, the benefit of this one is that regulation would set out which countries are prescribed, and therefore you don't need to make an assessment as to whether or not their privacy laws provide comparable safeguards. And the final option is to have arrangements in place to ensure that the information is properly protected. So this is putting in place a data protection agreement, which is quite commonplace under Europe's GDPR. Helpfully, the Privacy Commissioner is currently working on a set of standard clauses that will be made available to everyone with a view to helping create a data protection agreement to comply with that last limb, if that is the option you go down. The action here is to think about your data sources and where your information that you collect is being sent. And if it is being sent outside of New Zealand, whether any of the parties to whom it is sent are either a service provider and they only process it for you, in which case you don't need to worry about the new IPv12, or if they're going to use it for their own purposes, you will need to update that contract depending on which of these limbs may apply. Turning then to one of the key elements of the new 2020 Act, and that is a new regime requiring privacy breaches to be notified. Now, what I'm going to do here is talk through what the regime is and then run through a couple of examples. So the first step in the regime is assessing whether or not there's a notifiable breach. And there's two parts to that question. Firstly, has there been a breach of privacy? And that is defined quite widely. It covers accidental access to information, accidental loss of information, unauthorized access to information, and unauthorized loss of information. It also can include situations where information becomes unavailable, such as it's locked up by a cryptolocker. But just because you suffer a privacy breach doesn't necessarily mean it's a notifiable breach. The second part of the trigger is whether or not the breach has caused or is likely to cause serious harm to the individual to whom the information related. Now, serious harm isn't defined in the legislation, but there are a number of factors set out there that need to be considered. And these are things like what was done to reduce the likelihood of harm as following the breach, who got hold of the information, whether the information was sensitive or not, what protections existed to stop the information being used, so was it encrypted, for instance, and also what the nature of the harm might be that's caused by the breach. There are also some exceptions to whether or not a breach is notifiable. These are largely based around some sort of prejudice. For instance, the health of the individual affected could be prejudiced by telling them about the breach. There are also some defences that can apply. For instance, if you reasonably believe that there's no requirement to notify, then if it turned out there was a requirement to notify, you won't get pinged. Assuming there's a breach that is notifiable, step 2 applies. So what is the notification? The first thing is, who do we need to notify? And that's both the affected individual and also the Privacy Commissioner. When we have to notify, it's as soon as practicable after becoming aware of the breach. But there is a right to delay notification. Oh, just lost my light. If, for instance, notifying would increase the risk of further security issues, then you can delay notification to the affected individual, but not the Privacy Commissioner, until that security risk has been dealt with. What you have to notify, the Act sets out a number of requirements. The 2 key ones are based around what happened and what actions are you taking. And an important point to remember, you're responsible, the customer is responsible for any breaches by the service provider. The key action here is to work out what data you hold and put an assessment process in place in relation to that data. And this should be part of your breach response plan so that you are ready for dealing with a breach should one happen, rather than having to scramble as to whether or not it's notifiable at the time it occurs. So let's look at a couple of examples now. So our first example is we have Paul, who needs to send some payroll information to Kate in his organisation. He types up the email, autocomplete puts in Kate's name, he doesn't quite check it properly, presses send, and it's gone. He then realises autocomplete had put the wrong Kate into the field, and he sent his email to Kate at a different organisation. He realises the error and contacts Kate. Kate deletes the file and confirms it hasn't been accessed or copied. The good news is the 2 businesses are in an ongoing contractual relationship. Paul knows Kate quite well and regards her as reliable and trustworthy. So looking at the regime, the first question is there a breach? Clearly there is, because there's been unauthorised disclosure of personal information. Secondly, what about, is there a risk of serious harm? I think in this case, we can say no. A couple of the factors that need to be looked at are really key here. And that's who got the information, and that's someone under an ongoing relationship, someone regarded as reliable and trustworthy. And what action was taken to reduce the harm? Kate was immediately contacted. She deleted the file, and we'd want to make sure that it was out of inbox and trash, and it didn't go into backups. And she's confirmed it wasn't forwarded on and wasn't accessed. So we're very confident that there's no actual harm from this breach. Therefore, no requirement to notify. There would still be some actions that Paul's company should take, particularly around training and reminding staff to carefully check email addresses before sending them out. Our second scenario involves an e-store, and it's engaged an e-marketing firm called eMarketer to communicate with customers. Chris at eMarketer discovers that the e-store's mailing list has been downloaded by an external party. It turns out that Peter had received an email with a link that he'd clicked on, and it turned out the email was from a third-party attacker. The link put some malware on his computer and it compromised his login details, which were then used by the external party to get a copy of the mailing list that eStore used, which included names, email addresses, gender, mobile numbers, home address, etc. To make matters worse, eStore also discovers that its customers are receiving emails pretending to be from it and asking for credit card details. So again, if we look at the framework here, the first question is there a breach? Clearly, yes, there is. There's been unauthorized access to information. What about the risk of serious harm? In this case, we'd say yes. We've got the possibility of credit card fraud here, the potential for identity fraud. There's also a real risk that a number of eStore's customers are going to fall for this phishing campaign and actually provide credit card details, resulting in potential financial loss, not to mention the stress resulting from this hack, given the information made available and the emails that eStore are seeing sent to its customers. So the action in this case, we need to notify the customers and we need to notify the Privacy Commissioner, and we need to do it promptly. What we need to tell them, we need to tell them what's happened and what is being done about it. So eStore would have reset Peter's login details to stop any further access to its computers, run a security audit to see if there is any other code that's been left behind. They'd also want to start thinking about using two-factor authentication for login to reduce this type of risk. The information to the customers also needs to outline some actions that those customers would take too. The obvious things here are to tell them to be on the lookout for these types of emails and to delete them, to make it clear eStore would never ask for credit card details, but also to say, if you had provided your credit card details, contact your bank straight away. Right, that's the notifiable breach regime. Moving on now to some of the other changes under Privacy Act 2020. The main change on the Commissioner's new powers is the ability to issue a compliance notice. So this is where the Privacy Commissioner doesn't think that your privacy practices are up to scratch and comes knocking, wanting you to improve things. Now, you won't receive a compliance notice out of the blue. They will engage in a discussion process first, some sort of consultation to better understand what you are doing and to outline what their concerns are. And the idea is that the Privacy Commissioner and the agency would be able to work out what needs to be done and put that in place to the Privacy Commissioner's satisfaction. If, however, the agency isn't playing ball, then the Privacy Commissioner can issue a compliance notice, and that will set out what steps have to be taken and the time frame within which those steps must be taken. It will be mandatory. The Privacy Commissioner will be able to enforce it in the Human Rights Review Tribunal, but you can appeal it if you disagree with the requirements of the compliance notice. There is also a power for the Privacy Commissioner to publish names of people to whom compliance notices are issued, part of their existing name and shame campaign if they think your privacy practices are poor. Three other powers that I wanted to mention. The Privacy Commissioner will be able to direct access to personal information if an agency is not providing it on request by an individual. That will also be enforceable, also appealable. There are some more tools for investigations for the Privacy Commissioner. These are largely around the fringes, but they include the ability to shorten timeframes for requesting documents. The standard under the 1993 Act is 20 working days. So it could be less. Those 20 working days have been used in the past to draw out investigations. There's also a new power if a complaint is not resolved to the Privacy Commissioner's satisfaction for the Privacy Commissioner to take whatever other action it considers appropriate. Now, we don't quite know what that might be at this stage, but we're expecting some guidance from the Privacy Commissioner over the next few months on that too. Lastly, they'll be able to better share information with overseas agencies to deal with global privacy breaches. So we can share information, or rather the Privacy Commissioner can share information to his overseas counterpart for their investigation and get information in return for his investigation. The key thing here is around the compliance notices. So make sure your privacy practices are compliant. So this is about checking your existing policies against the current rules and the minor updates, and making sure you do comply. Please bear in mind that marketing in particular is an area where the activities undertaken can often get out of step with what's on your privacy policy on your website. That's an area where we're typically needing to make a number of updates to people's privacy policies. Lastly, just want to talk about the fines and offences. A new fine is being introduced in relation to the notification of breach matters. This will be a maximum of a $10,000 fine for failing to notify a breach to the Privacy Commissioner where it was required. OPC means Office of the Privacy Commissioner. This is not a fine for having a breach, it's a fine for not notifying it where you should have. There are also a few new offences which also carry a maximum $10,000 fine. These are failing to comply with a compliance notice, misleading an agency, or knowingly requesting a document. That brings me to the end of the section on the new legislation. One thing that has not changed in the legislation is IPP5, which requires you to have reasonable security in place. That continues under Privacy Act 2020. So Colin will now talk about some of the protection measures that are available to help with that.
Yeah, thanks for that, Graham. Yeah, I mean, what I'm going to go through today is a bit of a meandering through some security options that organizations can have, and fundamentally they do relate to privacy of data and the privacy changes, but also general security. I'll dive into some detail in certain areas as we go through. I'm going to start by putting up a little bit of a poll though, which I was going to do a little bit later, but I think it's probably a good idea. So I'm just going to launch a poll. So the idea of this poll is, well, this poll is what best describes the security and privacy priority for your organization. So it's just to give an idea of where you're at, as anonymous, for what would be your core central goal when you consider security and the systems that you implement, and what your priorities are. Got a bit of reading. Good mix coming through. There's about half of voted, so just give it a minute. All right. Okay, I'll just end polling now. So as you can see, most of the attendees here, the client, customer, and personal data security is the greatest concern, which is good. That fits very well with this webinar. And there's a couple of slides I've got just to go to discuss this. So one thing that Graham mentioned before that I'd probably like to highlight is the scenario, another scenario, which is what we see as the greatest, the most common threat to organizations. I'll just go on to the next slide while I'm talking through this. So the most common threat to organizations most recently is phishing attacks, which is one of the examples that Graham put up as well, I believe. So a common phishing attack that people receive is a Office 365 link that gets sent from a colleague, a company they deal with from a legitimate location, and they click on it and they go through it, and generally what happens, they log into their Office 365 and then their contact list is spammed with the same link. And organizations tend to go, whoops, that's really embarrassing, and reset their password and move on. Apologize to their contacts, of course. What they haven't often realized is that all of the data in the email is generally breached and often uplifted. So if you think about that in the context of this privacy change, there is whatever data you have in your email is hugely sensitive, and usually there is a huge amount of personal data. If you're an organization that deals with maybe clients that have, and you're dealing with them in a health related way, maybe with the MSD or the Ministry of Health, I'd imagine that your staff's emails have a lot of personal and private data in there, and it'd be incredibly hard to go through your emails and figure out what data has been breached and who to notify. It's on one hand, if you have a database breached, it's somewhat simple. Well, sort of. But if it's data and email, it can be incredibly difficult to actually know what has been breached. And so I think the idea is wherever possible, even these small breaches need to be protected against. Now, back to the slide. So traditionally, these were the areas of concern that we have come across amongst our customer base. So number one, if you go back 6 or 7 years ago, this was the only or number 1 and 2 were the concerns. So having data loss or being prevented from working, productivity loss, which a few people ticked. And then at a second level, it would be the organization or individuals having reputational damage. Well, one thing that we realized was about 5 or 6 years ago, crypto locker was a big thing. And we did have a few customers at the early part that were infected by crypto locker attacks. And what they would do is they'd say, right, we need to get up and running, get their backup sorted and move on. What I remember, and probably there's a bit of shame on us, to be honest, this is going back a few years though, there was generally never a question of, hey, is the data in this crypto locker, has our data been lifted off and could it be out there and on the internet? It just didn't come up because people were really focused on productivity and I guess reputational damage. Of course, that doesn't go for all customers, for all organizations and businesses, but it does tend that we are getting to a position where people are becoming more aware of their responsibility and how sensitive the sensitive data that they do have. So in order of historical concerns, and often the ability to protect goes in line with this as well. You've got prevention, working, reputational damage, then business secrets and finances being leaked out, then customer and personal private data being leaked. Then you get onto the more complex stuff, and I'm going to come to this soon, which is the accidental leaking of sensitive data, which was an example Graham put up from authorized personnel. And then the next step, which is generally the most challenging to protect against, is the intentional extraction leaking of sensitive data. So yeah, these are generally classed in 3 areas. So there's the continuity, which is the lost productivity and the loss of data, the data privacy and security, which is preventing it being extracted from unauthorized parties. And then there's the traversal, and that's when, trying to prevent data from being able to move around and out of your organization. And it does get a bit complicated. And generally the complexity does go in line with those. So I'm not going to spend much time on this because look at it, but this is how Microsoft sees its protection techniques for the data in Microsoft in Office 365 or Microsoft 365. So they have the beginning of the attack through to the entrance for the hacker, through to the traversal, and through to the data getting out. And each of these blue areas is an item of protection that they have available. We have used this to understand and learn and develop what we can do at the various phases of an attack or a type of attack to create protections and build something which could be quite helpful. So I'm just going to move through this at a reasonable pace, just so we've got enough good time for questions. So we've developed this scale, this system called the security scale. I won't go through it one by one, but the idea of this is, in order from 1 to 10, is you have a set of functions or features, I guess, or technologies that you could implement to increase your security in kind of order of priority and impact. And you've kind of got the first set, which if you're only a 1, you're not doing that well. But you've got the first set, which are really about protecting, in particular, protecting your data and trying to deal with the continuity and preventing data loss. As you go to the 5, 6, 7 and beyond, that's when you're getting into features that are specifically for trying to protect key and sensitive data and trying to stop things like, as Graham said, accidental sending of data or deliberate sending, exiting of data. And we're just going to go through a couple of these features, but what I would say are the highlights that you could consider. So yeah, just a bit on the security scale. The idea of this is, and there's a bit at the end and afterwards, if anyone's interested, we can provide some assistance for this. The idea of this is it's a group of technologies that the IT team use and industry recommended ones. Microsoft 365 and Office 365 is a big part of this, I must say. The idea is you can assess your position. That's the minimum we would recommend, and that is the recommended we would recommend. Obviously, there's nothing specifically compulsory here, but it's a guideline, a potential pathway. You could decide that you want to get to here, but it's going to take you a few years. So the key ones, the foundations, having a domain, having a pass-through policy, having AV, having patch management. These are the core things that everyone should have that will allow you to have a good foundational layer and prevent some breaches from occurring. Malware and potentially loss of data due to the loss of a laptop, for example, is going to be protected by things like having a domain and also having some baseline structures and policies. Cisco, Umbrella, and ATP, these here are the sort of the first strong defenders against phishing attacks. And phishing attacks, as the example I mentioned before, are the most common threat that is out there at the moment. Malware, getting viruses or flash drives, these things are pretty rare. The hackers located in China and Russia and wherever else, they are not building new viruses. They are working on complex phishing targeting attempts and other related, and ransomware in a way, but more so phishing, trying to, the biggest potential area of compromise is definitely through your email. Then moving on, we have a couple of items which are actually really important. So MFA, this is definitely the single greatest thing you can implement to improve your protection against unauthorized access, including phishing attempts. You can give over your password unintentionally and the MFA will stop them from accessing your data, which includes this customer data, whether it's in SharePoint or your email that we're referring to. DMARC, DKIM, and SPF. These are records to prevent or minimize the ability for someone to fake messages from someone in your organization, which could be related to getting your customer data from your customers or people in your organization or your clients or your suppliers. And then phishing campaigns. One thing that I haven't mentioned is the importance of training, and it's not touched on extensively in this webinar, but if we highly recommend doing phishing campaigns on a regular basis to test your team and bring up their training. And generally security training, and it isn't a one-size-fits-all model, is one of the biggest, most important things you can do for your team. Now, this is a very important one. So further on down the line, getting to sort of the 7 scale, so above recommended, we have DLP and ARP, and I wanted to talk about this specifically. So DLP is data loss protection or prevention. So the key function of data loss protection, and I could give, maybe I should have showed it, but what it is it's a feature that you can enable that allows you to stop data being transmitted or emailed out of your organization. So you can put protection measures. For example, if you were working with the Ministry of Health, you can put a policy that means that any Ministry of Health numbers, and you'd have to come up with the criteria for how it's laid out, that are in any documents or emails cannot be sent out of the organization except by a set number of people or a certain person or no one, or you can allow it to be notified if that does occur, which would give you a good, I guess, paper trail. So these are the types of things that are far above what a common company or organization would enable, but these are the functions that you can go to if you wish to step up the level of protection you would need. And I think from privacy point of view, this would be one of the, if you really wanted to go towards being highly protected and being aware of what's happening, so you're in a great position to notify or be aware if there's a breach, having DLP, depending on how far you do set it up or how heavy you set it up, I suppose, is a very good step. It is a bit complicated, but it is very, very doable. So this is an example of, true private, data protection of key data. Then we have things like MDM and conditional access. Conditional access is particularly relevant for this. It allows you to prevent access from people outside your organisation, from people in certain countries, outside New Zealand, outside of Christchurch or Auckland or Wellington. There's a lot of things that could be useful here. We're getting further down the scale, we're getting into the advanced functions, and I won't go into too much detail, but this is really when you're trying to prevent people, sometimes inside your organization, from sending information out. The idea is this goes down further, and it's just additional layers of protection. If you get to 10, it's getting on the extreme. So I wouldn't say extreme, but it's getting heavy, and you can go further, of course. But, we always say that eventually, if you have too much security, eventually you're not even going to be able to work. That's not the greatest mentality to have for us. But the idea is that you've got to find what works for you, depending on the data, how critical your data is. IP, for example, if you've got IP that cannot leave the organization, you might enable more functions. Okay. Yeah. So here, this is something we can offer a bit later if you're interested in learning more. But I do need to move on. So I just need to touch on Microsoft 365 Business. A lot of people on this call may not know exactly what license they have. The most common license, and Microsoft have changed the license types, but the most common license is the Microsoft 365 Business Standard. That's your Exchange and your Teams and your SharePoint and your Office suite. Microsoft 365 Business Premium, which is not to be confused with Office 365 Business Premium, is really the thing that allows you to enable not all, but at least some of the functions that I referenced before. We're anticipating more organizations to graduate to this plan. It allows us to get sort of past number 5 on the scale. It allows you to implement some of these things with better functionality. And so if you don't have this, some of the features that I've mentioned before are a reason to have it. It really is important if you're wanting to do powerful privacy and some of the powerful privacy protection functions. Okay, now what do you need to do? Over to you, Graham.
Cool. So this is really just summing up what it is you need to do that comes out of what we've discussed so far. So first of all, update your privacy breach response plan. So this is to incorporate the assessment process around a potential breach and whether or not it would be serious harm and you need to notify so that you're not having to deal with it right at that moment. Moving down to the bottom left, check your processes around collecting, storing, using and disclosing personal information. So this is around that compliance point. Make sure that what you currently do complies with the 1993 Act and also that it complies with those slight changes to the principles under the 2020 Act. And update any of those processes as necessary. The third area is around contracts with suppliers and other third parties. So given that a customer is responsible for breaches that occur at the service provider level, it's also important that your contract with them requires the service provider to notify you of a breach so that you can assess whether or not it has to be notified per the legislation. And then the other point around IPP 12 that I was talking about, if you're providing information offshore to another entity for that entity's own purposes, make sure you've got the right level of contract in place if they're not otherwise covered by one of the other exceptions, such as being in a jurisdiction subject to privacy laws that are comparable to New Zealand's. And the last point is around some of the practical side of things. So deploy the right technical protection measures and ensure that you've properly trained staff as well. They're one of your key lines of defence. So they should understand basic account security, how to report a phishing email, and so forth. Conan, have you got anything to add to that?
No, that's really good. I mean, it is sometimes about understanding how far you should go, you know, and that one of those earlier slides I put up was trying to understand what is important to you. Obviously, most of the people in this presentation talked about personal data, and in some ways, personal data does mean you need to go further than an average organization that is dealing with other businesses, because the worst that happens with them is, well, they obviously lose data and there's reputational damage, but they aren't going to have the Privacy Commissioner knock on the door and publicly name and shame them. So I think there needs to be an understanding of where you wish to be, and then try and figure out what technical steps you need to take. So question time. I'm going to ask Graham just a couple of questions that I came up with, and then we'll open it up. I've got a couple of questions rolling in. So as I said, we'll go a little bit beyond 3 for those that are willing to wait around, but fire through your questions as we go through. So Graham, GDPR is obviously something that's been in the news over the last few years. It's the big UK privacy law change, which was pretty heavy-handed, it seemed. Could you tell us, I guess, how does that compare to what has been put up? What the privacy law changes in New Zealand? Any key things in there?
Yeah, thanks, Conan. So GDPR, the European General Data Protection Regulation, which came into force in May 2018, is generally regarded as the gold standard in privacy and data protection requirements. One of the big things that it introduced was mandatory notification of data breaches. So our change in the Privacy Act 2020 brings us in line with that obligation in Europe and the UK. Now, we don't have as stiffer penalties for not notifying. Ours are the $10,000 fine I mentioned earlier. The GDPR has a fine of up to 20 million euros or 4% of global turnover. So that's a significantly bigger stick, but they also have some bigger fish to catch in terms of what they've been doing with the likes of Facebook and Google to date. There are a number of other things in GDPR that we don't have. Some of those we might get soon, and we might get some sooner than later. One thing under GDPR is the ability to port your data from one organisation to another. And last week, the government through MB released a discussion paper on New Zealand having a consumer data right, which is basically the ability of the consumer to require the provider to port its data to a new provider to them. That's in discussion mode at the moment, and they're seeking feedback on the discussion document, which is open until the 5th of October. A few other things in GDPR that we don't have. There's a right to be forgotten. So in other words, a mandatory requirement to delete data. At the moment, we have obligations to delete data under Principle 9 when it's no longer required. But this brings it forward a bit in GDPR. GDPR also has increased security measures. It requires mandatory data impact assessments, or privacy impact assessments as we know them here. And the ability to transfer information overseas is a bit more rigorous than our new IPP12 is. One question, given that we were just talking about it, that popped up is who's liable for the non-notification fine? As the Act stands, it's the organisation that is liable for not notifying, rather than any personal liability for directors.
Just one more question I'll ask before we go to the crowd. So marketing data, you gave a really interesting example, and you did allude to it. So, and I've got to figure it out for the IT team. So, you know, let's say we're taking data for a newsletter or website data, which we do. We would generally get information to allow us to understand our audience, age, for example, gender, I guess. There's probably a few other things. We probably don't go too far. But is there a concern, or is there any guidelines, or maybe even have an opinion on how marketing data is treated? Because to be honest, we don't need to know that they are 20 to 30. We believe it helps us understand our audience, but that kind of means we just want to know in a way.
Yeah, well, and that's part of the key question, really. So this comes back to IPP1, which requires an organisation to have a lawful purpose for collecting the information. And the lawful purpose has to be connected to a function or activity of the agency. So you can't just collect data because you want to find out something because it's interesting. You have to think carefully about what is the function or the activity to which the personal information relates, and then is it necessary to collect it for that purpose? And if you're just collecting it because it would be nice to know what sort of demographic people fit into, then that's unlikely to comply with Principle 1. Wow. But if we can tie it to a real good reason for knowing that information, so somehow it will enable you to better market to your customers because you better understand what their demographic is, then that will be fine.
Do you anticipate a change to how sort of marketing firms, as in, you know, people that might cold call you or survey you, will, I guess, seek that information and conduct the way they work? Or will they just go under the banner of it's to allow us to better market to our customers?
Well, it's interesting. It's not a principle that typically gets terribly much complaint about. It does sometimes. And often those questions are voluntary. So if you don't wish to share the information, you don't have to, rather than them being an asterisk field that you have to fill in. Whether it changes the dynamics of those organisations that do cold calling for market research purposes, not sure. Given the Privacy Commissioner's compliance notice option, it's likely that they will be more careful about making sure that there is a legitimate basis for the collection that is taking place.
Couple of questions that we'll just go through. So Harry has asked, after the 1993 Act, there was a health information code released afterwards. Does this new 2020 Act cover all the health information queries without a separate code?
It's a good question. And there are a number of privacy information codes that have been released following the 1993 Act. The Health Information Code is certainly one of the key ones. Others include the one around use of credit information. The 2020 Act doesn't import the codes into the Act. What is being worked on are replacement codes that will line up with the new language of the 2020 Act. So one of the things the 2020 Act does is modernize some of the old language. The substance doesn't change, but it uses slightly more modern language than was used back in 1993. So all of the codes will continue. They will be all updated and all released in the next few months prior to 1 December, so that they work under the new 2020 Act. Based on the way the codes work with the 1993 Act, expect the new codes to largely be the same as what the old codes were, just with a bit of modernization of language and the same tweaks that are in the IPPs that I talked about flowing through to the codes.
Okay. Hopefully that answered your question. Harry's a bit above my head. There's one from Lucas, which is there a guideline for marketing services that obtain databases via website registrations or competitions? Might be a bit of similarity with the question I asked before.
So in terms of marketing guidelines and also other resources that might be available to do this, the Marketing Association has good guidance around collecting data relating to marketing, as does the Privacy Commissioner's website. In terms of resources available for doing these sorts of things, if it's a very simple website and your data collection and purposes are very straightforward, the Privacy Commissioner has its Privomatic automatic website generator, which can be used to generate a privacy policy. Often we find that the collections that people are undertaking and the purposes for collection is a lot more complicated than that privacy generator can deal with. We have a set of questions that we put to anyone to help develop a privacy policy for a website, so that all the typical things are focused on, and we can then fairly quickly generate a privacy policy based on what actually is being collected and what information it's being used for.
So regarding cyber insurance, can cyber insurance benefit this, and namely under paying for a potential fine, if you're aware?
Yeah, so it's a good question. Cyber insurance is certainly a very useful backstop. If there is a breach, the policy itself can help deal with some of the financial implications of the breach. It can also provide a business continuity type income stream if you're completely shut out as a result of the breach. It often covers financial amounts that are payable. However, they need to be generally tied to or arising as a result of the breach. Now, the way New Zealand's new 2020 Act is written, any fines that arise will be a fine for failing to notify a breach rather than from a breach having occurred in the first place. So as currently drafted, it is unlikely that any cyber policy would cover the fine that might arise from not notifying.
Okay.
It's not to say that the policies might change in the future.
And lastly, Mahali's asked, Graham, do you have any free resources / templates we could use, e.g. privacy breach response plan or website privacy statements, etc.?
No, and I answered that a little bit in relation to the marketing question before. Really, if you've got a very simple requirement for privacy statements, then the Privacy Commissioner's website is the best place to go and use their automatic generating tool. They also have some very good information on breach response as well. Notifying a privacy breach, whilst it will become mandatory on 1 December, has been encouraged by the Privacy Commissioner for well over a decade now, and they've got a good toolkit there that can help you put together a some aspects of the breach response plan. But your breach response plan itself ought to be a combination of input from security specialists, as well as your entire team, and possibly some legal input to run through all the scenarios and exactly how you deal with it and who would undertake what actions. But certainly the information on the Privacy Commissioner's website is a good starting point.
Excellent.
We also help clients put together some of those things as well, in conjunction with security experts.
I've just pasted a link to the privacy.org.nz. There's some resources in there, which may be some of the things you're referring to, and also just a bit on where you can find the full act. So that is. Have you got any other comments you want to make, Graham, before we wrap up?
No, that I think that covers it.
Great. Well, look, thank you everyone for attending, and thank you very much, Graham, for giving this this talk. The reason we pulled you in is because you're a subject matter expert. Just so everyone knows, Lane Neave is not a customer or a supplier of ours. We dealt with Graham when we saw him speaking about this, and so we wanted to engage him, and I'm glad we did. If you need to contact, if you want some more information, please contact Graham. His email and details are here, and yeah, I'm sure they would be very keen to assist. Yeah, look, please fill in the feedback that should hopefully pop up when you exit or when we close this webinar. And yeah, we hope to see you in the next one. Thank you very much.
Great, thank you everyone.
Take care.